We're also very happy that we have with us Karuna Nundy. She is an advocate of the Supreme Court of India, specializing in constitutional litigation, commercial dispute resolution, among other things. She advises civil society movements, United Nations organizations, and governments of various countries. Uh, that word company, that was a slip of the tongue, I assure you. Firm, okay, firm. Limited liability. Okay, so Karuna has worked with various governments and advised them on how to improve their legal systems and how these systems can conform to international and constitutional legal standards. She's a member of the Columbia University's Project Committee for Freedom of Expression. In India, she has drafted contributions to new anti-rape laws, the Right to Food Act, among other laws. And we have something in common. She holds a degree in economics from St. Stephen's College. Then she went on to study law from the University of Cambridge and the Columbia Law School. And she's qualified to practice law in India as well as in New York. And we are particularly happy not only because she's here, but while we were writing the book, Subir and I, we went to meet her and sought her advice, and she gave us some very, very, very good advice. And some of her suggestions have been included in the book, and we have a chapter. We have Mr. Manas Saikia is not here, Speaking Tiger. He had brought out a book which gives you, it's like a guidebook. It tells you a little bit about if you're going to be sued or if you are sued, what you can do. So in one of the appendices that we have over here, we've tried to look at the fine print of the law a little bit, and it's titled Feel Free to Publish. So may I request Karuna to say a few words.
Thank you, Paranjoy, for that most generous introduction. Without further ado, I think there's a way in which our liberal democracy has a particular gap. And that gap is that it is essentially silent on corporate powers and how they must be exercised. And this is from someone who also represents corporations. Now, in terms of criminal defamation, I mean, there's no doubt that we're all agreed. I am representing Greenpeace with some others to, before the Supreme Court, asking for them to quash the criminal defamation law, and let us see what happens with that. Moving on, though, to the strategic lawsuits against public participation, because they actually are slaps. You know, I was doing a workshop with media lawyers from the Northeast and Odisha, and they represent papers like Samaj, papers that are not large, and even a 10 lakh suit against a paper like that can have it run the risk of shutting down. It is true also, and of course in the criminal defamation matters, we are arguing that because criminal defamation originated because people were trying to defend their reputations before the Star Chamber and they were dueling. That's why the criminal defamation law was formulated, and that corporations as legal entities do not have honor. I mean, I'm not saying that there aren't some lovely corporations out there. There are. I mean, they're sustainable. There's some good corporations out there, but it can't be said that they have that dignity, that honor that must be defended in criminal defamation. But I do think that they must have some right to civil defamation. But where is that limited? What is happening now? Oligarchies, of course, thrive on secrecy and competition on transparency. What we're seeing now is a rise of the bullying by a number of corporations, and very usefully Subir and Paranjoy have cited the CPJ data on this, the Committee for the Protection of Journalists, saying that this is one of the greatest threats now. Even though in India now we have people being shot, we have journalists being shot for doing their work, suits by corporations are some of the biggest threats. So in terms of the cases we've been dealing with, this book is actually fantastic because it's As Mr. Nariman says, it's racy. It's a great read. I finished it in one day. Um, but in terms of the cases that we've been dealing with, they include a lab that was looking at whether mangoes are, how much pesticide is used in the mangoes that we bring and eat in the market. It includes environmental activists speaking of forests being cleared unlawfully, protected forests being cleared, lands being acquired for mining. It includes things that are squarely within the public interest. And increasingly, we see a pattern of the small freelancer, the student in Calcutta, in the National Law University in Calcutta, the little guy, little girl being picked on. She was 22 years old. And not the institution or the publisher that has been associated. We also see instances of publishers folding. Now, what is the legal way around this? Doctrinally, how can we deal with this? Can we bar corporations from suing at all? Clearly not. Everyone has a right to come to court. Everyone has a right to that access. But at the same time, the Supreme Court has to some extent grappled with the question. In the Rajagopal case, for instance, what was said was that the New York Times versus Sullivan standard was incorporated. There are some high courts, and there is some, with some doubt, however, there are high courts that have followed that standard as now being law. And that standard is that you either had to have knowledge that something was untrue or reckless disregard of its truth. Now, what that does, because sometimes you can just get something slightly wrong. Everyone has deadlines. That's not that much of an excuse. But there are confidential sources that need to be protected. And there are times that you make statements that are inferences culminating from a number of facts and a number of things that you've considered. And clearly these are things that must be protected. Now, New York Times versus Sullivan, this was considered to be the breathing space that is required for the media. And for that breathing space, we must now start to act on the actual malice standards in individual cases that come before us as lawyers. In the patronage, in the Rajasthan Patrika judgment, for instance, the High Court, the Delhi High Court, has been taking quite a leading and salutary role in developing the nascent slap jurisdiction. As far as we are aware, the Rajasthan Patrika judgment mentioned the strategic lawsuits against public participation for the first time. And what it said was that as soon as the suit is filed, you can go and say that the statements in the suit do not disclose a cause of action. What that does is that instead of embroiling the journalist or the writer into decades of litigation and having the sword of Damocles of 100 crores hanging over him or her, at the outset, it is now possible to go and say that this suit must be dismissed because it does not disclose a cause of action. What that also does, and that means that either that the corporation has failed to prove the damages, and the onus is on the corporation, not prove, but to state the damages, I beg your pardon. The proving only comes later. That to state, with prima facie evidence, that that the corporation's reputation has in fact been damaged. The defenses of truth, etc., only come in later, but at this stage there is a very important step that needs to be taken. The Petronet judgment does something quite interesting also. What it does is that it expands the Rajagopal protections from public functionaries and the state to public functions, which means that in certain circumstances, the actual malice standard also applies to corporations. In the Money Life judgment by Gautam Patel in the Bombay High Court, there is an absolutely stellar judgment by which he says that the NSE should not have prima facie sued Sucheta Dalal and Money Life for massive damages, and in fact awards 50 lakhs punitively, something that is at least approaches a deterrent. Now, what is the task before us? I think the task before us is, let's not forget that the strategic lawsuits against public participation in the US are a creature of statute, right? Now, what is the likelihood that we'll have a statute here on that? Very limited, I think. But what is possible is to, because this is a constitutional issue, is to take appropriate cases to the Supreme Court and to have propose to the court that these various high court judgments be spelt out and articulated in a definitive Supreme Court judgment. There is a way in which a number of diverse parties, from Greenpeace to Subramaniam Swamy, have come together asking for the quashing of criminal defamation, and we hope that the same would happen if such a case is approached. The second thing is that I think Order 7, Rule 11's applications as soon as a case is filed by a corporation to dismiss that case, I think that's something that all of us should do. We've been doing it ourselves in many of our cases, and we have also been training lawyers in other parts of the country to do it, and there has been, some success, some failures. But I think that immediately is the way forward. And what that also does is that at the legal notice stage, then corporations know how far they can go and how far they can't. And it also, if there's a sufficient precedent that is established, then already in the bargaining position, the power changes. Lastly, but because I think this is possibly the most important point, there is a massive failure of self-regulation in the Indian press. We see the kind of rubbish that destroys people's reputations, invades people's privacies, and there is a way in which I think that enables and in fact makes it an imperative of courts to step in and limit that freedom. This, of course, is a travesty. That's not something that can happen because the press also plays such a salutary and important role in terms of holding power to account without proper, and I think, journalists' employment security and the act, the law that concerns that is something that's very important. And without very much money and, in the great public interest. But I think that self-regulation is extremely important, and it's not happening effectively. And this is, once there is self-regulation that occupies enough of the field, there is a lot then that can be excluded in terms of outside regulation. I will also say that increasingly with freelance and the rise of freelancers, the rise of individual bloggers, the rise of people who are not associated with large media organizations, that it's important with the self-regulation also to make sure that people are protected. That people who are, pursuing a journalistic function are adequately defended, not just lumped with the baby when you are sued for hundreds of crores and the publisher folds or the news network folds. That there is a body that takes care of that, a lot of us are doing as much pro bono work as we can. And Mr. Nariman is actually a free speech hero of mine in that regard. But a formal organization of journalists that can address this issue worldwide, I think, is extremely important. But this is a brilliant start because we always knew this was a problem and we've been talking about it and we've been litigating it. But this establishes the pattern and this is a problem statement. And now it's up to us to make sure that that problem is dealt with.